welcome everybody to the first SBU of 2025 with the Fresno Chamber. This session, as all of the sessions, is sponsored by Noble Credit Union. They have been great partners for the Chamber, and they offer a program where they will do free financial education for your employees. So I own a couple businesses actually, and we've taken advantage of that service, and it really has been helpful to our employees. So big thanks to Noble Credit Union. And this one is always my favorite SBU of the year. Ian Wieland is a board member here at the Chamber. He's also the managing partner at Sagasser, Watkins and Wieland, and they collectively are considered certainly among the top, if not the top law firm in our region when it comes to HR issues and wage and hour issues. It's a real privilege for me to attend this. I've attended it every year, even before I worked here. So without any further ado, I'd like to hand the microphone over to Ian. Thank you so much, Ian. How scary is this year going to be for employers?
It's just it's like every year, right? It's part of doing business in California, as we joke. But I think in compared to like previous years, we're gonna get into it and go over the changes. I would kind of, there's the landscape remains unchanged, like wage and hour, as I'm gonna go into, is number one threat. But compared to previous years where it seems like we've had just some major changes, things to be aware of, it's a lot of, small things, but things that you should be aware of and update your handbooks for. So, thanks for having me today, Scott. It's always a pleasure to come to the Fresno Chamber of Commerce and speak. And the law firm's honored because we've been doing this for the chamber for some time now. And so I'll just dive in. And so as part of like some housekeeping, since we're on Zoom, for the sake of time, I'll try to cover these things, relatively quickly. But as you have questions, feel free to, send your questions through the chat box, and we'll try to answer them as we go. And I'll certainly leave time at the end for Q&A. So I think we can just dive into the subject matter at hand. So we'll go to the wage and hour slide. And so, just briefly, this is on purpose. So, wage and hour. So as I would tell any employer, any client coming in, I think wage and hour is going to be the biggest threat to your organization, your business. I say organization because I realize not everybody is for profit. I know most folks out there are for profit, but this also is a threat to nonprofits. And essentially, PAGA is going to be out there, and we'll talk about PAGA reform here in a bit. But we have DLSE audits, CLL audits, and so wage and hour is going to be on the forefront, as it has for the last several years. So just make sure you're on top of all your wage and hour requirements moving forward. And we'll go to the first slide, which is state minimum wage. And so this is on here, just a reminder, we all should know, as in previous years, just January 1, the minimum wage is going up. And so it went up to $16.50 per an hour. And just a good time to like check in, like every January, February, we get calls from clients. I literally had one yesterday where they forgot that when the minimum wage goes up, they also need to check and make sure all their salaried exempt employees are making at least twice the new minimum wage, right? And so that increase is now $68,640. So yeah, just a good time to just go through and just make sure everyone's making at least the minimum wage for their hourly rate, but also your salaried exempt folks. You don't want to have someone that's making 65 grand or 64 and just shy of it. If you happen to find yourself in that camp, don't make a big deal about it. Just, fix it. And I would try to, spin it as a positive. And what we do in this situation when folks reach out of just, hey, if you're gonna continue to, pay that person as a salaried exempt employee, turn it into, hey, you got a raise, we appreciate you, and turn it into a positive. I also realize as the minimum wage goes up and the exemption status price tag of having to pay someone a salary to be exempt goes up, we do have some clients that have strategically made the decision to pay some of those folks hourly. And just keep in mind, right, if we're saying someone's exempt, they're salary exempt, we want to make sure they properly fit in that exemption. But the default is always hourly. And I just flagged that because I've had some situations where folks, as just the cost of doing business goes up, just in some positions just can't continue to really justify paying a salary moving forward. And so those are, the topics minimum wage, but those are, two of the main things that come up this time of year associated with exempt status. And so we'll go to PAGA reform. And so, folks that are involved with the Fresno Chamber and the Cal Chamber and other trade associations, I just want to point this out that this is actually a positive. So kind of just, backing up, going into the summer last year, there was a ballot initiative on the ballot for November, and it was to repeal PAGA. And for those that might not know what PAGA is, it's the Private Attorney General Act of the Labor Code from 2004. It was signed by Governor Gray Davis as he was leaving office, and I've heard from several folks that he's publicly acknowledged that he made a mistake in signing this. But it essentially allows a current or former employee that's worked for an employer going back a year to bring a representative action against the company for labor code violations going back a year for PAGA penalties. And what happened over the summer is, I think the plaintiff's attorneys, the plaintiff's bar that actually files these cases in mass, I think they really freaked out because there was a huge coalition that had been formed to defeat PAGA, and they went to Governor Newsom and worked out a compromise. And so with any compromise, it's not perfect, but it at least, to really summarize in the simplest terms, it allows employers to get less penalties if you get hit with one of these, and it makes it easier for a defense attorney like myself to defend an employer if you're in one of these cases. And there's actually some major plaintiffs firms that have kind of seen the writing on the wall and are switching to something else. And there's a couple of guys that just retired. Now, there's still plenty of firms out there that'll take these cases, and they will for the next few years. But this is overall a good thing. But I do want to give a shout out to the Cal Chamber and the Fresno Chamber and the San Joaquin Valley Manufacturers Alliance, and on the statewide basis, like the new car dealers, Western Growers, California Fresh Fruit, Farm Bureau, etc. Because without business coming together, PAGA reform wouldn't happen. And I would just pause for all those people that are in these various trade associations, because it actually shows when business comes together and works together that we can actually get things done, even in California. And so I think moving forward, hopefully all the various business organizations can, form a stronger coalition to help, make some, changes here in the Golden State. But as I mentioned, just some real key, takeaways on PAGA reform. So if you get a PAGA notice, and this is going to be really important, is make sure you contact your labor defense counsel, whether it's our firm or another law firm, and jump on it, because The second bullet point is cure violations. You have 30 and 60 days to jump on it and show that you're, doing things to correct any potential violations, and you get penalty reductions. Also, just moving forward, like, and you should be doing this already, but you get penalty reductions if you're a good employer and you're taking all reasonable steps to stay in compliance. Because PAGA, we don't like PAGA. It's very much a compliance statute. They want people to comply with the law. And so when they're using the words all reasonable steps, that means going to employment in labor seminars like this one to keep up on the new laws. That's updating your employee handbook every year. That's updating all your relevant wage and hour policies and practices. And so it's important to do that, but also keep records that you're doing this, and it's used to help reduce penalties. So even if worst case you get a PAGA notice, we look at it and we find some really tic-tac violations, it'll help get the penalties reduced if we can show that you're someone that's trying to do things right, which is what most of our clients and what most employers are. You're trying to do things right, but just make sure you just keep the evidence of you attending seminars like this one, updating your employee handbooks, and trying to stay compliant. And yeah, I could spend a whole morning going over the PAGA reform, but the important takeaways are there's mechanisms to help make PAGA a lesser threat if you get hit with one. But the important part of it is jump on it, contact your legal counsel as soon as you get one, and work with that individual to help you, get through it. So overall, and there's some negatives about the PAGA reform. I don't love the tight 30, 60 day deadlines. For perspective, there's been some situations where I get a new case from an insurance carrier and it's gone through the pipeline, and by the time our law firm gets it, it's on like the 70th day, right? And it's like, well, the 30, 60 days have run, or like, or to use another example, like someone just sat on it, didn't do anything until a lawsuit was actually filed, and the 60 days has run. So don't love that, but still, even if you're in that situation, it's important to just jump on it, make these corrections as soon as you possibly can if you have violations, and get those penalty reductions. But also, probably the most important takeaway is before you even get a PAGA notice, it's important to just make sure you're buttoned up on wage and hour. I realize just from experience, like some people need that shock of getting a potential lawsuit to jump into compliance, but you don't want to be in that situation. You'd be much better off if you're on top of it, you're doing things right, you get a PAGA notice, and then we can help you show to plaintiffs counsel or the state or both that you really did nothing wrong, and that's where you want to be. So we can go to the next slide, Scott. So construction industry, I just kind of have this up here as more of a ha-ha because, we have on record in, the Assembly Labor and Employment Committee, all the construction trade unions going to the state complaining about how bad PAGA is, and getting all the construction trades that have that are union excluded from PAGA. And so I just kind of find it like pretty humorous that, usually the unions and the plaintiff's side trial attorneys are in league, kind of pushing outrageous employment and labor bills. But even in this situation, the construction unions have recognized, the carpenters in particular have recognized how bad PAGA is and have got themselves exempted from it. So going on to the next one, Freelance Worker Protection Act. So this is a bit of an odd one. So basically, it's putting into practice that if you're hiring a freelance worker and you're paying them compensation for their work, that there has to be a written contract. And so obviously, from a practical standpoint, what I would be concerned about is, just about every business out there, we have vendors that we do work with, whether it's janitorial, different folks depending on your business that you might be contracting with. And obviously, in most situations, if you're dealing with a company that has an LLC or an Inc., they're going to have a contract. But where I think this is going to become more of an issue is just a one-off individual, right? And in making sure you have a contract with them in writing. But where I kind of see this being a potential issue is it could be a trap for the unwary, right? Because we have really strict independent contractor rules in California. And I always find it to be a red flag as someone that's defended ED audits where they literally come in and they audit your 1099s and see if you have anyone that's misclassified as an independent contractor. From a practical perspective, like having sat in my law firm's conference room or in clients' conference rooms through those EDD misclassification audits, what they literally do is just go through your 1099s or they'll pull a random 10 on 1099s, and depending on your investigator and how cool they're going to be with you, and the ones that like stick out, it's not the Sagister Watkins and Wieland or Gazebo Garden or Wieland Consulting LLC, right? Like they like blow past those. The ones that like stick out are like a person's name and a social, like Scott Miller and a social, Ian Wieland and a social, John Miller and a social. Like they go, oh, like who's this person, right? And so, I would just say if you're gonna have a written contract with someone, and you're paying them as an independent contractor, just really make sure they qualify as an independent contractor. Because if you're doing something with a freelance worker and you enter in this written agreement because you're trying to comply with this law, you might be entering into a trap of evidence of have an independent contractor situation that's not on the up and up. And just keep in mind, what I like to see with these independent contractor relationships is us doing business with a legit business, which is going to be an LLC, C or S corp. So it's a business to business exemption under the ABC test. And then if it's really an individual, you really have to kind of question it and be like, hey, is this person doing business with others? Is this really a situation where if we have a misclassification situation being alleged, can we defend it as being a legit independent contractor? So just be aware of that. I don't want you to fall in that trap. So we'll go to the next category. So changes to California's discrimination, retaliation, and harassment laws. And we'll go to the first slide. And so for those that are updating your employee handbooks, certainly when we're going through and updating employee handbooks, we're making sure this is something that's addressed. So this first one is a new category of protected trades, and the category is intersectionality. And I'll admit, as an employment attorney, back in October when I was looking at all the new employment and labor laws that had made it out of the legislature that were signed by Governor Newsom, I saw the term intersectionality and I was like, I don't even know what that is. And so I had to look it up, look at the legislation, and it's basically a combination of two or more protected trades. So like, for example, a female and the female's race, or it could be a disability in gender. From a practical perspective, as a taxpayer, I'm kind of like, why is the legislature wasting their time on this? Because obviously, if you're discriminating somebody, based on one protected trade, that's illegal. And certainly if you're doing it on two or more, that's illegal. That's already California law. So I don't know why we had to clarify this, but we did. And so since it's out there, when we're updating folks, your anti-harassment, discrimination, retaliation, or EEO policies, I'm literally just going through and adding the term intersectionality as a protected trade. So just be aware. It doesn't really change anything from a practical standpoint, but this is something that was added. Let me go to the next one. So again, this is a another change when we're updating the anti-harassment, discrimination, and retaliation policies. And so it's making broader protections under the Fair Employment and Housing Act for protective hairstyles. And so that bullet point, when we're going through and updating employee handbooks, we're literally just adding in that new definition as part of a protective trait under race. So California Worker Freedom from Intimidation Act. And, I did a couple seminars before the new year, before the holidays. And this wasn't a thing, but now that the new year's hit, there's been a few trade associations that actually filed lawsuit challenging this new law. And I think the Cal Chamber was one of them. But here's the situation. So basically this new law prohibits employers from requiring employees to attend employer-sponsored meetings that convey the employer's opinions on religious matters or political matters. Seems pretty straightforward, and obviously we cannot threaten or discharge employees for refusing to attend such meetings. But what this is really aimed at is if you're an employer and you're going through a union campaign where you have a union actively trying to campaign to unionize your employees, or you're just trying to prevent potential labor organizations from unionizing, what often happens is there's meetings where a labor consultant or even an attorney like myself will go and present on why employees shouldn't unionize. Or if you're in a campaign, you're basically countering the messaging that the union's providing to the employees. And so the biggest concern about this new law is this prohibition of forcing employees to attend these meetings that are about unionization in the employer's perspective on why they shouldn't unionize. And so, one, we'll see how that litigation, plays out if they're able to overturn this on constitutionality matters. The other opt-out, by the way, is it focuses on mandatory. So it says you can't make them mandatory, but obviously if you say they're voluntary, you tell the employees they're going to be paid to attend, you can still have these meetings. And certainly if you're facing a union campaign, we would advise you, hey, let's make sure we do this. Let's make sure it's voluntary. Let's make sure it's in writing. There's no uncertainty that it's voluntary, and you can certainly incentivize people to still attend. But we'll see how this legislation holds up in court. I mean, I just like the trade associations that filed the lawsuit. Don't think it's constitutional, but we'll see what happens. So going to the next one. So driver's license requirements in job postings. And so this is just, I think from a practical standpoint, when we get into some of these things, it's just making sure you don't use old job postings, old forms and documents. I think that's where a lot of clients get in trouble, or sometimes I'll see things in a personnel file that come across my desk that clearly haven't been, updated since Ronald Reagan was president or something. And so just be wary if like, hey, you're using something older, like a job application or a job description. There's been a lot of changes, like including not being able to ask, criminal history type questions until you make a conditional job offer. And so now we have, driver's license requirements in job postings. And so basically we can't ask a job applicant for a driver's license if the job itself isn't, requiring a driver's license, right? So what I would do is look at the job, and is this person going to, actually be required to drive as part of the job? Do they need to drive? Do they need to have a valid driver's license as part of their, essential duties, or even some incidental duties of the job? Because if they don't need to drive, like for example, there's even, jobs in my office, file room, receptionist, secretaries, doesn't matter how they get to the office, to and from work, as long as they're they're here, that's what matters. And we're not asking them to drive as, part of their regular duties, right? And so I think if you just go through your positions and just make sure you update your job postings, and obviously if it's a job where they're required to drive, need a valid driver's license, that's fair. But for jobs moving forward, you know, need to make sure that that's not part of it. And so one common question that we get, right, is, well, someone, might need to show a driver's license for an I-9 to show that they're authorized to work in the United States. Well, keep in mind, that's just one document. And actually, as an employer, it's up to the employees, right? If you look at the I-9, the employees have a choice of what documents they can show us to show that they're authorized to work in the US. And if we actually dictate or control which documents, you can get in trouble for that. So just be aware of that issue too. So we go to local enforcement of employment discrimination. So this one, I guess we can kind of laugh about this now, Scott. I don't know. I don't maybe not. But so when I was presenting on new laws last year to a lot of, organizations like the Fresno Chamber, Madera Chamber, farm bureaus, groups of that, there was a similar law that had just, come out going into 2024 that allowed local jurisdictions to prosecute labor commissioner claims, right? Wage and hour claims. And I jokingly would say, hey, I think this is going to be more of a deal in the Bay Area or in LA, where you have an overzealous DA or city attorney that's trying to make a name for themselves. I don't expect to see much of this in the Central Valley. And then sure enough, city of Fresno went and enacted their version of a labor commissioner hearing, and we're still waiting to see exactly how that process is going to play out in the city of Fresno, how they're going to handle those. But I bring that up because, like, similar parallel, like, you're going to have the ability for local jurisdictions, if they want to start their own enforcement mechanism, similar to the state, they can do that. Now, what I would say, just like I said in response to the city of Fresno, is like, why? Like, if you're an employee and you think you're wrong for a wage claim, you can go down to the labor commissioner office on Shaw Avenue across from Fashion Fair Mall and file a claim. You can go on Google and type that in, and 1,000 plaintiffs attorneys would represent you. It's just, I just don't see why it's needed. And, like, same thing for this one. Local jurisdictions are obviously free to do it, but I just think it's a waste of government resources, because the employees, if they want to file a claim under the Fair Employment and Housing Act, they can go to the state civil rights department, used to be called the Fair Employment and Housing Agency. And we respond to hundreds of those every year, just like the federal government has their own EOC. You can file a claim there. You can file a claim at the state. You can go see a plaintiff's attorney. So, knock on wood, hopefully our local jurisdictions, do not, try to do this, because, again, I don't think it's needed. I'll get off my soapbox on that one. Leave. So paid family leave. So, so basically this is a little nuance. And again, this is one where I think just go through and make sure you don't, have something that might just be there, in your employee handbook, and just updating that language under paid family leave. But essentially, for paid family leave, you're not able to require employees to take vacation before they receive their paid family leave benefits. And to put things in, like, context, because you might be like, why is this even an issue, Ian, or why are we talking about this? If you look at a lot of employee handbooks, a lot of employers, maybe not a lot, like a good percentage of them, will say, if you're going to go on FMLA leave or CFA leave, you need to take any accrued and unused vacation or paid sick leave in connection with that. And that makes sense, because FMLA CFRA is traditionally their unpaid leaves unless the employer does something more generous, and so they're requiring the employee to use some type of wage replacement. For paid family leave, the employee is already receiving a wage replacement when they take this leave. And so I can see why the state is saying no, employers, you're not going to make them take a vacation when they're already receiving a benefit. And so just be aware of this. And obviously, this only applies to paid family leave. I do see a growing trend though. I have a lot of clients that get audited by major, customers, and they're required to use just good practice guidelines, whether it's Walmart or Costco. And it seems like the growing trend from those organizations like Whole Foods is to get away from forcing or controlling employees' ability to use vacation time in conjunction with leaves. And so I see the state of California going in that direction too. So just be aware that's a growing trend when you're looking at your policies moving forward. So go to the next slide. So, this is more of an FYI. Small employer family leave mediation program and reproductive loss leave. So there's a pilot program that the state enacted. So if you're a smaller employer, which some of you on the seminar might be, if you have between 5 and 19 employees, and 5's key because if you have to have at least 5 employees for the Fair Employment and Housing Act, and most of these leave laws even apply to you. So if you have 5 to where you have jurisdiction, but 19 employees or less, and you have, let's just say you messed up for whatever reason, you didn't attend a seminar like this, or you just weren't on top of all the different family leave and reproductive loss leave laws, or you just maybe didn't handle that technically, proper, you can attend a, mediation, through the state and get that resolved. So just an FYI, and obviously if you're going to do something like that, I would make sure you work with legal counsel before doing it, because just, a claim like that can have significant monetary liability and also some non-monetary liability. So just be aware of it. So victims of violence. For this one, it's moving the jurisdiction, and it's more for those that potentially might face a claim of this nature. But previously the labor commissioner would enforce provisions entitling employees to victims of violence leave. That's now going to be enforced by the California Civil Rights Department. I guess from a practical standpoint, as someone that's trying to look at this, like, why are we doing this? It kind of makes sense because the labor commissioner's office is looking at more wage and hour issues, where a leave law, would more appropriately be under the CRD, who's already enforcing harassment, discrimination, retaliation laws, and as part of that, other leave laws. And so, just more of an FYI, and hopefully you're not in this situation to where it matters who's trying to enforce the law because you potentially violated or were accused of it. So for our ag employers out there, this is just a change for the ag industry related to like paid sick leave. And so, and I also flag it just because, more and more, just be aware of the industry that you're in. Because more and more we're seeing, very state specific requirements for certain industries like healthcare, construction, janitorial, fast food, ag, right? It's a growing trend and it's just not going away. And so if you're an ag employer for paid sick leave, make sure you update your paid sick leave policy and notices to the employees to include that employees can also use paid sick leave to avoid smoke, heat, or flooding conditions. And this is the key part, created by a local or state emergency, right? So you have a local jurisdiction, or you have the state, Governor Newsom declaring a state emergency due to a, wildfire with smoke or heat or flooding conditions, and an employee wants to use, paid sick leave for that, then they certainly can. So again, just for the ag employers out there, make sure you include this in your paid sick leave policy moving forward, and that you're aware of it if someone asks about it moving forward. So workers' compensation, um, again, more of an FYI. We can go to the slide. So notice to employees. So, and again, like if you're working with to make it really easy on you out there, I always try to think, if I'm an employer, which I am, like what's the easiest way to comply with this? Because even at our law firm, sometimes we go, oh yeah, we've been telling everybody that we need to apply with this stuff, but we need to update our own law firm employee handbook. We need to make sure we have all the postings too. And so from a practical standpoint, we all have workers' comp and insurance brokers. Just make sure, in all the workers' comp defense firms that we work with have been sending these out, but just make sure you have the latest notice to employees, which will include now that they, have the right to consult with a licensed attorney to advise them of their rights under the workers' comp laws. And it's just in there. And so just make sure you're using the latest and greatest notice. And just from a practical standpoint, I mean, I look at a lot of this stuff, and this isn't really a big deal for us on the employer side, because the reality is, employee files a claim, and yeah, there's a rare situation where they might not have an attorney, but the system itself is created in a way that it encourages them to get an attorney, and it's easier if they have an attorney. And so it's really not that big of a deal, but just make sure you're using the current notice. The next slide on workers' compensation on e-signatures. So with workers' compensation documents, it's now allowing electronic signatures, which is something that's been kind of recognized across the board in most venues. For whatever reason, and from time to time, we will appear in workers' comp for 132A and serious and willful claims that aren't covered by workers' comp insurance. And workers' compensation has just been really archaic. Like forever, you couldn't sign any documents unless it was in black ink. They wouldn't accept blue ink. Had to be black, and they changed that a few years ago. And now they're allowing e-signature. So good job, workers' comp. Welcome to 2025, like everyone else. Disclosure and posting obligations. So whistleblower posting, again, more of an FYI, this is a new law that's going to require the labor commissioner to develop a model list of employee rights and responsibilities under whistleblower laws. And by the way, there's a lot of them. And so they're going to develop this poster, and when it's developed, we'll have to post it. And I'm sure what'll happen is, at the end today, I don't want to steal Scott's thunder, but for those that are attending, you do have the ability to get a free Cal Chamber poster that has all the postings. It's what we use at the law firm. It's what I give the clients, unless they're in a really industry specific one like ag or construction that have some additional requirements. If you're an office employer, or most employers, you could just use the Cal Chamber poster. But when this gets done, it'll eventually, be included in the poster that just gets bigger and bigger and bigger, that goes on the employee break room. So just FYI, we can go to the next slide. So disclosure requirements for social compliance audits. And so, just keep in mind, if you are an employer, and more I have clients, because they're trying to do business with certain entities. For example, I mentioned Walmart, Costco, Whole Foods, folks of that nature. I have other clients that are part of certain trade associations, or they want certain organic symbols to be able to use, or just sign offs on certain requirements. If you're doing any of that, that's considered to be a social compliance audit. This is something that you're going to be, mindful of. If you're not, just, one thing to consider if you're looking at doing that. But if you do, voluntarily subject your business to a social compliance audit, you have the responsibility now to post a report detailing the audit findings on your website regarding certain information. And so a lot of folks that are on the Smarter Day, this isn't going to apply to you, but obviously, if it does, I would advise you work with your legal counsel to basically make sure you're in compliance with it. And for those that haven't done it, I've had to work with numerous clients that'll reach out to me and be like, hey, I was working with this vendor or this client, or I want this certain ability to represent this logo that I'm certified in these areas. And so we were going through the social compliance audit, and they, depending on who it is, I've seen some where they literally go through your employee handbook and they suggest or require you to make changes that from a legal perspective you don't have to do, but they're wanting you to do it to show that you're complying with social compliance standards or just good policy standards from their point of view. And so just something to think about. And if you're going to look at doing that, make sure you get all that information up front, and you're okay with that before jumping in, because it is a lot of work. So occupational health and safety. So this is a reminder for those that might have missed it, but going back to July of last year, Cal OSHA has a new requirement for indoor heat illness standard, and it'll kick in for any indoor work area where the temperature equals or exceeds 82 degrees Fahrenheit when employees are present. And so, just make sure, if that's you, and there's a lot of folks that could fall in that situation, including my office when it's 110 outside. So just make sure you have a heat illness prevention plan, just real simple, and that the employees are, trained on it. And you have some, emergency response procedures in place. So if you missed this one, just make sure you're on top of it. And if you have, any questions, the one thing about Cal OSHA, if you go to their website and you're missing an injury illness prevention plan, you need the indoor heat illness standard, all that good stuff. They have really good models on their website where you can literally take their model of whatever you need and just go through. It's like fill in the blank. They make it really easy. Just go through and create your own. So if you're missing any of that stuff, just make sure you get it. Like, and I'll just kind of pause and just on a practical perspective, we also defend a lot of Cal OSHA citations, and probably one of the most common, if not the number one citation that we see, is an employer just failing to have the paperwork. And what I mean by that is, you have an employee injury that you're required to report, accident happens, something, Cal OSHA shows up, and you've done everything right. Like in regards to what actually happened in that incident, you did what you were supposed to do. There's no safety violation, but the investigator asked you a question like, where's your injury illness prevention plan? Or where's your, outdoor, heat illness prevention plan, things like that. And if you don't have one, or you don't have one available like you're supposed to, that's a citation. And so just make sure you have all that stuff. And if you don't, there's no need to freak out. That's easy to get, easy to comply with, but just make sure you're on top of that. So workplace violence protection plans in hospitals. So again, just really specific for hospitals, but Cal OSHA is going to require that hospitals in California have workplace violence protection plans in place by March 1st of 2027. So just a FYI, I also flag it just because, I think it's important to just keep track of, what's going on, what the state is doing, even if it's not your industry, because there could be ramifications, or by the way, this could be something that other employers or significant, portion of industries might have to do, moving forward. And and it's something that I just be aware of from a practical standpoint too. More and more since COVID, the last few years, we get more and more phone calls from clients about workplace violence situations. And so just something to be mindful of. Obviously, separate from that, we have requirements as employers. If something were to happen, but I just mention it because it is more and more of an issue, and just make sure we're being safe out there. And obviously, if there ever is a workplace violence, and like sometimes it's an employee making threats, it can be an ex-spouse, significant other coming on. I've even seen it from like vendors that regularly come to the property. This day and age, you gotta take that serious, right? And so if there's anything like that like happens, like don't hesitate to, contact law enforcement. And certainly if it's a repeat offender, a law firm like ours can help you get a cease and desist, get a restraining order against certain people. But it is a thing, and it seems like more and more every year we just have more and more client requests regarding this topic. So just be mindful of it. So I'll open it up for any questions. Obviously we went through a bit there, and like I started off, like there's a lot of what I would say minor things to be aware of, a lot of just more, updating of your employee handbook, and making those changes and just aware of certain things. But if you have any questions about that, or if you have any questions in general about any employment and labor topics, feel free to ask away.
I should also mention at this point that this has been recorded, so everybody who's on today will be able to get a copy of it, so that in case you missed anything, you can always go back to it. I actually have a question about the freelance written contract. Is there like a lower threshold where it's not required, like if you call a handyman to do something at your business, or for my business outside of the chamber, I was thinking of bands. We'll do a lot of 1099s to bands that play at the nursery, but we rarely have a written contract. I think never probably have a written contract with them.
Yeah, no, I think, yeah. So like what I don't like about that law is like two aspects. Like one, just the way it's written, it's overly broad, because like from a personal standpoint, just like you, Scott, I was looking at it like, how does it impact the law firm as a business, and just me personally, right? Just because there's folks that I interact with, like I have a handyman come to work on my house or whatever, right? Do I need to have a contract? So I think, from a technical perspective, we should, because, it's to protect those individuals. Now it's really what it's trying to do is, like, the intent of that law is to protect people that the state perceives as folks that could be employees, that are like freelance writers, things of that nature. So certainly, folks like that, I would make sure that we have a written agreement with. But then there's folks that I would say, if they're an independent contractor, like for example, you're doing, business with the handyman that comes, or you have the band that comes, and some of this stuff is like, what's the risk, right? What's the liability? Like, I've seen folks that are like handymen, like try to sue the company, something goes wrong, and they try to say they're an employee, and try to spin it. And so obviously in those situations, I would make sure we have some documentation about what this is. Like, you're not an employee. We're hiring you as a contractor. You represent to us others that you do business as others, right? And try to have that, not only from a freelance standpoint, but from an independent contractor standpoint, that this is very much what this is, in case they flip it on you. Now, as you're going up, it's like a band, right? I think there's less risk there, because you're very much hiring this band, and yeah, for numerous reasons, it might be good practice to get an invoice from them or some type of basic, documentation. But at the end of the day, I think, everyone's going to kind of know like, okay, this is what this relationship was. But obviously, I think the more trickier ones are the handyman, like the one-off gardener, the one-off, these are all ones that I've like seen from clients, by the way. The one-off janitor person that doesn't really have a company, but like just comes to your place and does janitorial work, and kind of questionable if they do work for others or not, right? I think those are the ones that I'd be more concerned about.
Thank you. I think, and please, anybody, you can raise your hand if you have questions or put questions in the chat. But I stay freaked out about this kind of stuff as an employer because it's one thing that I have learned over the years, largely through interactions that include you, is that it really doesn't matter what your intentions are. It doesn't matter if you're looking out for your employees and being a good person. There are technicalities that will catch up to you. So it really pays to get your processes audited by somebody who knows how to do it, to really be up to date on this information as an employer, because failure to understand the law or the rules is not won't get you out of the trouble when it comes.
Absolutely. Yeah. And I can't mention the client because it's not public record yet, but that handyman example hits home because I literally just got a case a couple months ago where, a client was using this handyman up in the mountains, and he's a handyman for everybody. And he's upset because they're not using him anymore because he wasn't really doing a good job. And now he's trying to sue him and say that he was an employee, and because he was an employee, he wasn't paid properly, didn't get wage statements, didn't get his breaks, all this stuff, right? And obviously, I think we're going to be able to defend it, but in that situation, in this business, like they didn't have any contract with this guy, right? They didn't have anything, right? And so I think just more and more, because a lot of the different threats out there, whether it could be independent contractor, whether it's is this guy an employee, I think it's just best practice to just be upfront with people and just say what is this deal, and whatever it is, let's get some basic writing down and understanding what the terms are, just so you can be protected and someone can't flip it against you down the road, or so you don't fall under this freelance worker law, or independent contractor, or the employment laws, right? So that's just one recent example, and there's a bunch that I've seen like that. So just even more reason to make sure we're on the up and up there.
There's a question that was in the chat here. Great presentation, Ian. To piggyback off Scott's question, what about a one-off that is just finishing a project that was started by a company, Bitwise, but was just short of finishing, so they are just bringing it home? They will get 1099s. There's a contract laying out the scope of work, and most, if not all, have regular jobs.
Yeah, so great question. And I mean, again, this goes into like, like the like freelance issue is one thing, but also I'm also concerned, if not more concerned, about the state's really strict independent contractor laws, right? And so I would want to make sure, again, this individual, if it's just their name and a social security number, that's what gets flagged by the state. Of this, is this person really a contractor? And if they're just doing a one-off thing for you, an argument can always be made of like, well, is that something that an employee would do? I don't know your business or anything, but I think in those situations, particularly if the person is an individual, they're not a business. Um, I would want a basic agreement with this person, even if it's independent contractor agreement that spells out all the things that make a person an independent contractor, so you can at least rely on it. Because again, I've seen some situations from IT folks, and I don't know what this person's doing, but I've had some IT guys that are like literally just small, working out of their house, doing some IT work for a business, and then the relationship goes sideways, and now they're trying to argue they should have been paid as an employee. And that I've had those situations where the business didn't have independent contractor agreement or anything spelled out. And so I think even in a one-off situation, if they're doing a fair amount of work for you, it's going to be best practice to like do that. Now, obviously, we always look at it from a practical standpoint too, of what's the liability, what's the risk, and so if it's literally someone doing something for you, like a one-off thing for one day or a couple days, like what's the risk there, right? Is it really worth it? But if they're going to be doing something for you on a more long-term basis, then the potential risk and liability just increases and even more reason to be buttoned up. But that's something you kind of have to gauge as any business, right? So hope that helps.
Okay, well, that is pretty much our hour. As always, Ian, thank you so much for this. This really, I honestly believe this is the most valuable hour of the year. To the attendees, you'll have access to this recording through all you have to do is email Jimena, who is the person who emailed you the link. Also, you'll be getting a questionnaire immediately following to ask you what you thought today and what topics you'd like to hear in the future, because we do care about making sure we're doing what our members want. And again, finally, thanks again to Noble Credit Union for the ongoing support of this program. So thank you all very much. Oh, also don't forget to make sure that Jimena has your address so we can get you your poster. Again, thank you, Ian. Thank you to all the attendees, and we'll see you next time.